All right, y'all, we're starting right at exhibit number 2, and anytime a case opens with exhibits, you know someone is about to get exposed. Pay close attention here. This is where the story of promises, childcare deals, and emotional expectations begins unraveling.
Exhibit number 2, is that a discussion that you had with Mr. Hernandez about childcare after he had moved out?
Yes.
When you talked to him about possession and access of Israel, well, let me ask you this. Did you ever talk to him about what his possession and access would be, or was it only about childcare?
March 8th, when, he took my mother to Oklahoma, he had told me, that was when he said to me that he wanted a divorce, and he was fine with, us going our separate ways, but that he had no intention of taking Israel from me. He just wanted to be in Israel's life, have some form of visitation. He was going to give me $600 or $750 just to help out with the bills, as long as we don't do child support or go through the Attorney General.
So, were you surprised when Mr. Hernandez started asking for...
Did y'all catch that? First he says he doesn't want child support, then suddenly jumps to 50-50 custody. In family court, that shift is huge because 50-50 often reduces or eliminates child support. Question for the comments: do you think this was financial strategy or genuine fatherhood?
50-50 possession and access of Israel?
Yes.
Were you surprised when he pled to be primary?
Yes.
Okay. After the February conversation, did you ultimately agree to use his mother again?
Yes, until I secured my own childcare.
Okay. Did you ultimately find your own childcare?
Yes.
And when was that?
I think about in April.
And were there times when you would still use your mother-in-law after April?
Yes.
Okay. And specifically, petitioner's exhibit number 5, is that a possession calendar that you put together?
Yes.
And you would indicate on there by dots the nights that Israel was actually with you?
Correct.
And were there often nights, even when you had to work, that Israel was with you?
Yes.
Okay. And do you believe that Israel actually lives with Mr. Hernandez when he is with Mr. Hernandez?
Speculation. Sustain, rephrase.
Do you have any concerns about Israel actually living with Mr. Hernandez when he's with Mr. Hernandez?
Because he's living with his mother, not necessarily Esteban. Esteban is not really.
This right here is a subtle bombshell. She's basically implying that the father isn't actually the one caring for the child during his visitation periods, the grandparents are. Judges pay attention to who is doing the actual caregiving, not just who claims the time on paper.
Most of the times, he's not there. He's probably in his girlfriend's place.
Let's see what the question was. Do you have any concerns about Ezra actually living with Mr. Hernandez when he's with Mr. Hernandez? Would you like to take her on the voir dire?
Sure.
Okay, go ahead.
Ms. O'Connor, how many times have you seen Mr. Hernandez at the residence that he states that he lives at?
Talking about his grandparents' home?
The residence that he states that he lives at.
His grandparents' home, or?
The residence that you believe the children are at during his periods of possession.
That's his grandparents' home.
How many times have you seen him at his residence?
A few times.
Okay, when was the last time that you saw that he was not there when your child was there?
Oh, several times.
Okay, when was the last time?
It could have been a few weeks ago.
Okay. And how do you know he doesn't live there?
Well, he has a girlfriend, and I know he stays at his girlfriend's place too.
Motion to strike for lack of personal knowledge.
Sustain.
Ms. O'Connor, when did Mr. Hernandez first start living with you?
We started living together June 2019.
Is Mr. Hernandez currently the primary conservator of his 2 other children?
Yes.
What's the relevance, counsel?
Your Honor, this goes to Mr. Hernandez, his history and pattern of actually having custody of his children. If I could, sorry, not saying having custody, actually having possession and access of his children. He has 2 other children that never lived with him, even when he was primary. And this is Ochonagor believes that he's doing the same thing with his son, with
Okay.
their son.
Okay, overrule, I'll allow it.
So Mr. Hernandez moved in with you in 2018, and he finally moved out in 2025. During that time period, was he the primary conservator of his other two children?
Yes.
Did they ever live with you and Mr. Hernandez in your home?
No.
And did Mr. Hernandez ever even ask for the children to live there?
No.
Do you believe that the same thing is going on with Ezreal?
Yes.
Where did those other two children live the whole time that Mr. Hernandez lived with you?
It'll be sustained unless she knows.
Do you know where the other two children lived when Mr. Hernandez was with you?
Yes. Half the time they lived with their mother, and then when he had legal custody, they lived with their mother and his grandparents.
This is where the emotional tension hits a new level. When a co-parent asks to move communication to attorneys only, that's usually a sign things have gone from stressful to potentially unsafe, or at least deeply hostile.
And at some point, you asked for your communications with Mr. Hernandez to only go through attorneys. Why did you ask for that?
Because it was becoming very difficult to communicate with him. He was becoming very controlling and threatening. And just for my peace of mind, I just wanted us to go through the attorneys.
And has Mr. Hernandez ever been physically abusive to you?
Yes.
Objection. They have no pleadings on file with regard to any family violence or
What is your legal objection?
it's not pled for. It's scope. It's outside of scope. There's no-
Sustained.
Yeah, I would argue that
I've already sustained it.
oh, okay.
Go ahead.
So do you have any concerns with interacting with Mr. Hernandez?
What was the question?
Do you have any concerns with interacting with Mr. Hernandez?
Sometimes it's very difficult to communicate with him. He becomes very controlling and threatening. Yes.
And has he threatened you with physical violence?
Objection. Scope.
Your Honor, can I respond?
Hold on 1 second. I was stopping. Okay. Has he threatened you with physical violence? What's the relevance?
Your Honor, I think that if there's a history of, I won't say I think, I know that if there's a history of physical violence, that goes directly to not just conservatorship, but possession and access as well. And so in this case, there is an allegation of that. And we're trying to deal with it as nominally as we can in this case, so that we can at least deal with possession and access.
So the issue is that in your amended petition, it doesn't specifically cite any family violence. What
In
it
my
does,
petition?
hold on, let me make sure this is yours. Sorry, that's her amended petition. 1 second. Let me go to your counterclaim. Okay, so yes, in your counterclaim, you mentioned a history of committing family violence. However, on your request for de novo appeal, there is not a specific request for the court to, what it says is, okay, so let me ask you this, because you may have to clarify your question. Are you asking specifically about family violence in regards to possession and access, or in regards to conservatorship? Because the request for de novo says respondents.
Important moment, the court basically says they can't entertain the family violence claims today because of how the paperwork was filed. This happens a lot. Even serious allegations can't be addressed unless they're in the correct procedural box. The law is strict about due process.
Request that a possession order be entered that is designed to protect the safety and well-being of the child or any other person who has been the victim of family violence.
So in this case, Your Honor, because of the timing to answer the question, we're trying to deal specifically with possession and access only, because I think we can deal with the rest at the end if we have to.
Your Honor, that summary request for relief that you're looking at is actually supposed to have been. It's the what?
It's the request for de novo hearing.
So that request, so the request for de novo, there was a meeting with regard to that, and also Judge Lee did not make a finding of any family violence. So, like, that's not supposed to be being heard right now.
Well, and I do agree, because the in order for me to entertain it today, there would have had to have been a denial of a finding of family violence, and then you put that within your request for me to entertain today. But there's not even in her let me see, her associate judge's ruling, there isn't a I don't even see anything where it says a denial of a finding of family violence.
Right, Your Honor, which is why I simply pled that it be that we enter orders that properly deal with it. If the court believes that it exists, then I believe that it needs to be dealt with, because, and we actually talked about this on the evidence exchange, and I think that Judge Lee believed that she specifically denied it, but she didn't deal with it at all.
Okay. Well, and that's the issue, because they have to be on notice.
Well, they're on notice of they've been on notice of the claim that we wanted the court to consider it in making a possession and access ruling.
No, not that. They have to be on notice in the in the request for the de novo appeal. So by due process, what's that case? EM, you have to specifically plead the findings and the conclusions on a request for de novo appeal.
Right.
Otherwise, I can't entertain it. So because it's not even explicitly stated in the request for de novo appeal, I can't entertain it today.
Understood, Your Honor.
Okay.
So, Ms. Ochonagor, when you all could not come to an agreement for possession and access, did you specifically ask me to reach out to Mr. Hernandez's attorney to try to get an agreement?
Yes.
And are those communications represented in exhibit number 6?
Yes.
And did you have any concerns, or had Mr. Hernandez said anything to you that made you be concerned about him returning Israel?
Yes. He didn't. He stated he wanted the same time that I had with him, and I think him and his lawyer had even stated that since there was no order.
Would you like to take her on the order?
Well, she said she thinks. So that's where the regard to cause for speculation comes in.
Okay, sustain.
Specifically in exhibit number 6, where you advised that there were no orders and that Mr. Hernandez did not have to follow a certain schedule.
Yes.
Okay. And did you try to, I'm sorry.
Exhibit 7.
Exhibit 7, I apologize. Exhibit 7.
Yes.
Okay, so the exhibit 7 is the communication.
Correct.
Okay. And so
This is where everything boils over, when co-parents can't agree, not even after attorney-to-attorney communication, requesting a hearing becomes the nuclear option. Question for y'all, who do you think is being more unreasonable here based on what you've heard so far?
were you trying to get something in writing?
Yes.
And did you ultimately request a hearing when you guys couldn't agree?
Yes, I did.
And so when you requested that hearing, did you still offer Mr. Hernandez some time?
Yes, but he refused any other thing besides a 50-50 time.
Okay. Do you believe that you should have to pay Mr. Hernandez's legal fee?
No.
Why not?
Because I offered some dates. I did try to reach out to him, especially through my attorney. But he refused and wanted nothing but just a 50-50 time.
Has Mr. Hernandez, does he have his own home?
No.
Does he have a room at the home that he says that he lives in?
No.
Does Ezra?
does he have a room at the home that he stays or he lives at? Okay, would you like to take her under Vordar on that one?
Yes, Your Honor.
Okay, go ahead.
Ms. O'Connor, when was
Yes.
the last time you were inside the residence that Mr. Hernandez resides?
A long time ago.
Okay, so you don't know whether or not he has a room at the house that he resides in, correct?
He doesn't have a room. Because we're going to be together, and he just moved back to his grandparents' place.
She said so you don't know if he has a room where he resides at. Is that correct? That's a yes or no.
Yes,
How do you know he does not have a room at the residence in which he resides?
because he wasn't staying there. He was living with me up until February 1, 2025.
So as of February 1 of 2025, do you know whether or not he has a room at that residence?
I don't think he has a room in that residence.
Objection, Your Honor. Cause for speculation, motion to strike.
Sustain.
Just Mr. Chonagor, even prior to you all trying to make an agreement, did we specifically reach out and request a conference with Esteban's attorney in hopes of trying to get y'all on the same page
Yes,
prior to that?
yes,
And is that exhibit number 3?
yes.
You're concerned with Israel living with his grandparents. Do you have a good relationship with with his grandmother?
No,
Does she even answer your calls when you call to check on Israel?
no,
Do you have to have all communications through Esteban?
yes,
And does exhibit number 6, is that a summary of your attempts to call and when you had to interact with Esteban and his mother?
yes,
Okay. And are your communications often delayed?
yes,
And does that concern you as it relates to Israel being over there 50% of the time?
yes.
Ask the witness, Your Honor.
Okay. Counsel, you have 4 minutes and 45 seconds left. Attorney Lazanes, you have 13 minutes and 14 seconds left.
Ms. O'Connor, you previously stated that Mr. Hernandez missed Israel's first birthday. Is that correct?
Yes,
Did you tell him about his birthday?
yes.
Where was the birthday party at?
I was at my it was my resident, not exactly my resident. My friend's what is it called? Like a clubhouse. And I notified.
And you gave Mr. Hernandez this address?
Yes, I notified his mother so that he could have the twins.
Yes.
Sustain.
You stated that your friend's mother was watching Israel, but you previously stated that your family member was watching Israel. Isn't that true?
So when
Is Your Honor responsive?
Sustain. The question was, you stated that your friend's mother was watching Israel, but you previously stated that your family member was watching Israel. Isn't that true?
Your Honor, I'm going to object at this time. I think it assumes facts, not in evidence. I don't think Ms. Otonagora testified to anybody specific, who specifically was keeping him in this hearing.
Your Honor, if you
Hold
look
on.
at petitioner,
She didn't even answer the question. Hold on. She said you stated that friend's mother was watching Israel, but you previously stated that your family member was watching Israel. Is that true? That's a yes or no.
yes,
Okay. So what's your objection?
My objection was that it assumes facts, not in evidence. And then also at this time, I would say that the question is vague and argumentative. I would like a timeline. What are we talking about specifically?
Sustain this the time.
between the time of February 20th, 2025 until April of 2025, or I apologize, after February 20th, 2025 to today, did you or did you not state that a family member was keeping Israel?
yes,
And is your family member your friend's mother?
no.
What is the name of your family member that was keeping Israel?
Modinat.
And what is her relationship to you?
She's my in-laws. Sorry, my a sister to my brother-in-law.
So there's no blood relation, correct?
The
Objection, Your Honor.
relatives.
After no. Suspend. You stated that you were surprised that Mr. Hernandez had requested 50-50 of Israel. Is that correct?
Yes.
Isn't it true that Mr. Hernandez didn't request 50-50 until he had gone 2 months without seeing the child?
No.